Hi, I'm Connor Ritma, and I will be presenting Case 1 from Week 10 on antitrust law and employment. So, what are the basic facts of this case? Apple, Google, Intel, and Adobe faced a class action employment lawsuit that claimed these companies colluded not to recruit each other's employees, effectively suppressing salaries. The case involved more than 64,000 technical employees. These employees included software and hardware engineers, programmers, animators, digital artists, web developers, and other technical professionals. The initial investigation by the Justice Department also involved Pixar, Lucasfilms, and Intuit, but these three companies settled their suits before the class action was approved. Top executives at these companies, including Apple co-founder Steve Jobs, who was portrayed as the mastermind in court documents, made behind-the-scenes deals that these companies wouldn't try to poach employees from each other. These four companies were looking for a settlement because if they went to trial, numerous embarrassing emails would have been exposed to the public. Emails which would have implicated each of these companies in a collusion to suppress salaries. Also, if the case went to trial and the plaintiffs, who were seeking $3 billion, won, then under federal antitrust law, the plaintiffs could have gotten treble damages. Treble damages is a term that indicates that a statute permits a court to triple the amount of the damages awarded to a prevailing plaintiff. Thus, the plaintiffs potentially could have been awarded $9 billion. The lawsuit was first settled for $324 million, but the judge rejected it. The case ended up being settled for $1,500 million. What companies are involved? The companies involved were Apple, Google, Intel, and Adobe. Why is this an antitrust case? The definition of antitrust is of or relating to legislation preventing or controlling trusts or other monopolies with the intention of promoting competition in business. Therefore, the case is an antitrust case because these companies were restricting the competition by colluding together to not recruit each other's employees. By not recruiting each other's employees, this kept the salaries low and prevented competition in the business. Who are the worst offenders of the law? It seems like the worst offender was Apple. Steve Jobs, Apple CEO at the time, was considered to be the mastermind behind the agreements, and another article of Jobs said, if not the central figure in the alleged conspiracy. Jobs also bullied the other companies. According to court documents, Google tried to hire a group of Apple engineers, to which Steve Jobs said, "If you hire a single one of these people, that means war." It was also noted that executives from other companies were afraid of him and they did not want to anger him. The judge rejected the first settlement. Why? The judge, Lucy Koh, of the United States District Court in San Jose, rejected the first settlement because she believed it was too low and said the settlement would have to be at least $380 million. The judge believed the plaintiffs' lawyers to be taking the easy way out, and the judge thought the plaintiffs were entitled to more money. The judge was quoted saying, "There is ample evidence that Silicon Valley was engaged in an overarching conspiracy against its own employees, and it should either pay dearly or have its secrets exposed at trial." Why didn't the companies just have covenants not to compete in their employment case? Non-competition agreements tend to be disliked by courts because they inhibit competition similar to the foreign companies colluding together to suppress salaries. These agreements sometimes are viewed as unfairly restricting an individual's right to work, which can make court battles difficult to win for employers. In addition, non-competition agreements lead to an increased risk of legal battles, and they may make the organization less attractive to potential new employees. Thanks for watching.